Happy Saturday, everybody. Let's talk business with Dr. Crockett and AV. When you see the C,
you know it's me, and when you hear the C, it's Dr. Crockett and
AV. Appreciate you guys hanging out with us every Saturday, 10:30 a.m. to 11 a.m. And we trust that you will, as we always say each and every week, get your trust in order so your will can have some life.
Come on now, it's a real thing. And I'm so excited today, man. First of all, trust and wills are paramount. We want you to know that if you have a will and you don't have a trust, the guy that you just got gas from at the gas station could overhear your child talking about what they just inherited and file a lawsuit against your will. And if he got the right lawyer, he might have your assets. Man. That's just a fact of life.
That's a scary fact of life, because we want your will, say, to have the life and energy and the expectation that you set it out for. Because, Mike, we just saw some people go through the loss of a loved one, and what you said, you got family in turmoil because they fighting over, well, no, they promised me this, they promised me that, and you got the kids saying, no, this was promised to us.
Right.
So, no, wait a minute.
Come on now, and let me be clear. I'm so glad you said it that way. Right? So we just had a situation in the office this week. Sibling called us and said, well, look, my parents passed,
okay,
and it's two different wills.
Ooh, yeah.
Let me get extremely specific. I said it wrong. Let me correct myself so y'all can hear it the way they said it to me. They say it's a will and a trust, but the trust is separate from the will. So they left a will earlier, right? And then they went and filed a trust afterwards.
Yeah.
Right? So I'm so glad we got one of the greatest in the building. Our boy Brandon Cofield in the building. Harris County Probate. We're going to definitely bring him on the air. So watch this now. This is what I told him. I can't wait for you to tell me was I right or wrong. You understand me? He going to check me on the radio right now. So I told him, I said, look, the one that's the most recent is what carried the weight.
All right, so even though they got a will, right? So there's a will in place.
Yeah, but that ain't the will. But yeah, so then
they have
a trust. So they did a will, and then they did a trust later.
Brandon, help me out.
Yeah, I mean, it's going to depend. I mean, like,
go ahead.
That's the law school answer for everything is it depends. At the end of the day, if you didn't fund that trust, whatever asset that was, same way as, let's say you have a car.
I like it.
And you're talking about giving something away and how that gets crazy. You give the car to your grandson to drive.
Okay.
But the will maybe gives it to somebody else. And then you have a trust that's supposed to give it to somebody else. Ooh. Now, in that scenario, if you gave it to that grandson, that's what controls, because you can't give away what you no longer have. I mean, I can put the Astrodome in my will, leave it to my son. I don't own it, so I can't do nothing with it.
I like him so much. And so I'm finna ask him a real question on his scenario. I love having him on there.
Yeah. So that's why I say it depends on what the asset was and if it was funded. Because if you have a trust and you don't fund that trust, you don't.
Now I want y'all, first of all, let me say this. This is Brandon Cofield. He is a lawyer with a law degree, and he is over Harris County Probate. Yeah. Now, we're going to tell you guys what we're doing together here shortly, but I got to ask him a question about his scenario so you guys can understand what he's saying. He's mentioned one word 4 times, right? Fund the trust, right? So can you break down what funding the trust is?
Yeah, and that's one of those things that people, you better make sure when you get a trust that whoever is drafting that thing finishes through, follows through, and funds the trust. Because if you don't, you're going to have a piece of paper that isn't worth anything.
Seeing this consulting group, we fund your trust every time you get a trust with us. That's why we tell you to do it. But now we have an expert lawyer on the grounds, so we want him to go ahead and tell you what's going on.
Man, and a lot of people, I'm glad to hear y'all do that, because a lot of people are lazy and don't take that next step, because it can be onerous. To fund a trust means basically putting something into the name of the trust. So let's say you have a designated beneficiary on a bank account, or you can do it with a car. People usually don't, because then that makes people think that somebody's really rich, so they really kind of go all in. But in your house, let's say, you deed that from your name to the trust name so that it is already in the trust. So whoever the trustee is, they don't have to go through the whole rigmarole to try to get it into the trust later by going through the whole probate process. It's already been in the trust name. So that's generally what it means to fund the trust. So if you have a trust that says to do all these different things, but none of those assets are in the trust, and you don't have a will with a pour over that says everything goes to the trust, then that trust is just going to be void. I mean, it's just nothing.
Now, so you using some more of those great legal words, right? So pour over, right? When the will pours over into the trust, can you break that down for us?
Yeah. So it's called a pour over will. So you should always have a will when you have a trust. Okay. And even if that will literally says just basically the one thing, it's either a residuary clause or it's called like a pour over clause.
Slow down.
All right.
You got real legal for the people now. So residuary clause is?
The idea is if you forgot anything, I want everything to go to somebody or to the trust. So that's that pour over or that residuary. So anything, let's say the day before you pass, you got $1 million and you didn't include that in your will or in your trust or any other estate planning, you're not going to have a designated beneficiary most likely. This is your kind of fail-safe that says, in case I forgot anything, make sure this goes to this trust or this goes to this person. And as a catch-all, it prevents, because if something isn't included, then you have to go through the entire estate administration process because it wasn't included in a will. So then you kind of open up a whole can of worms. Now you got to figure out who the heirs are. Now you got to go through the whole probate process that you could avoid, that you're trying to avoid. It's just make sure you have that extra.
Now this is why, and this is, man, he's great. This is why we have unlimited changes for the life of the trust at CNS Consulting Group. So if you get something new at any time, if you have a new grandbaby, if you acquire new assets, if you hit the lottery and hit for $1 million and you want to allocate some things, you can add that to the trust to the trust and your will at no cost to you here at Crockett and Sons, right? But we want to let you know that there is a such thing as a pour over, which means that if you acquire anything and you didn't have an opportunity to add it to the trust, the way you word it inside of the trust and inside of your will allows it to pour over.
Yeah, because we don't want to lose $1 million.
No.
On that table, he is, of course, the public probate administrator. Brandon Cofield is our special guest. Harris County. And Brandon, what I want to know too, you said something about the process, like having everything because the business is not in place of the process. So what is that process like? What are some of the things that you have seen as you've gone through the process in your position that people deal with,
right?
Just when they have to go to probate court, because it's not pretty.
That's one of those things where I'm like, man, how much time we got?
We wrote it. We wrote it
all day long. Man, I think so. There's two different kind of avenues that people find themselves in with the probate space. It's either usually if you have a will or you don't have a will.
Right.
And when people are frustrated with probate and usually have that horror story and everybody kind of puts their head in the sand and they don't share that information with anybody, it's usually because there's not a will or there's not an estate plan. And the reason being is because you have to, one, unlike a will where you know who's supposed to be in charge, the executor, and you know who's supposed to get what, based off of what the words say, the court has to decide who's supposed to be in charge and then who's supposed to get what. Now, the problem is if there's a bunch of people, they call it you take, so a whole generation or class of people will take. So let's say there's 3 kids. All 3 of them are going to take, even if 1 or 2 are deceased. But what happens is they all have equal standing.
Right.
So now the court has to decide who's supposed to be in charge. And as you can imagine, the number of people that are like, well, I took care of mom for the last 5 years.
How do you prove that?
Why am I not in charge of this? So you got that first headache.
Yeah.
So then it's like a first to file, and then you're trying to prove the standard. Basically, there's a couple different metrics, but the final one is like not suitable, and it's a very vague term, and that's literally up to the court's discretion. But you can't say I don't like my siblings, so they shouldn't be in charge. Of course, like that. Right. Not a good reason, right? And so, but you can imagine people just want their day in court. So that's one of the things that holds it up. The other thing is you got to figure out who the heirs are, and the amount of times that you would think that it could be easy, but the way that it works, unfortunately, is if you know someone exists, you have to give them notice.
Yeah.
So that's a headache. If somebody's out of town, out of state, you got to show proof of giving them notice. So that can be costly. The other piece is you have to. The court appoints an attorney ad litem. Their job is to kind of serve as the guardrails for the court, because otherwise the court doesn't know if whoever filed the application is telling the truth or not. You might be trying to leave out your extra sibling that you can't stand, right? And so that attorney ad litem now, their job, they're going to be trying to pick up the phone, look through the obituary, death certificates, see what's going on here to try to get to the bottom of that. But sometimes people aren't telling the truth or they forget, and they're like, oh, now you have 2 different conflicting testimonies. And so I have a case that actually involved a prominent rapper here in Houston, and his siblings are taking. He's already deceased. His siblings would take, but they're trying to figure out who the siblings are, which you would think wouldn't be too hard. But you have the two witnesses that said, yeah, that was the sister, but really it was a half sister.
Wow.
And they were never formally adopted. So now you have the attorney ad litem, who's from a different culture, that's like, so the birth certificate says one person. Everybody knows that person on there is not the actual dad. Everybody knows that it's this person. But it's like, how do we overcome the actual document? So these are the type of things that kind of can happen when you have these cases and things.
Wow.
That it gets,
just get your trust and will.
Yeah, man.
Because y'all know in our culture we have things going on, and we don't want to have to get in front of any other culture to explain it.
Yeah, hey, we grew up in the Jerry Springer era tomorrow.
Who he is not the father. You did?
Yeah. Man, that's
especially separations.
Yeah.
My goodness, like the state doesn't acknowledge separation. That's not like a legal thing. Either you get divorced or you don't. But we all know people.
Slow down.
Long time separation.
Repeat that one more time.
You either get divorced or the state of Texas thinks you're still married.
Still married.
Yeah, y'all can live far apart, never see each other.
So there's an issue that I'm dealing with right now in the trust and will space. Right, there's a son that has a massive concern. His mother put her name and his name on his home. He's paid the home off. He got it down to $18,000, and then he lost his job. So his mother paid the $18,000 off. He's paid for the rest of the home. Let's just, for the sake of the conversation, say that home is worth $300,000. Right. So now the mother has a guy that she's been living with long enough for him to holler these two words. You remember we talked about words and what they mean over 50? Common law.
Yeah.
Right? So now you being a real lawyer, right? And he said, look, what can I do to protect my asset, right, from the boyfriend that's saying he common law, because the mom is liking him so much. She's saying, well, the house that we living in, if anything go on, whatever you want to do with it, to the boyfriend, which is acknowledging she willing to give over assets. But there is no agreement about who owns what percentage of his house. His mother and him are on his house together. So his concern is the mother giving the common law half of his house?
So there's layers to this. So the first question is, so they're both on this deed.
The son and the mother.
Right. So if they're both on there, then it's assumed that it's 50-50.
Right. It is assumed.
Right.
Okay, I'm just asking.
Because it's 50-50.
Regardless of who paid what.
There could be...
Wait. Mm-hmm. For the people listening, I'm asking a real question. Because it come through the office for real. Regardless of who paid what, if there's no agreement in place and the note has been paid by one person, but it's two people's name on that piece of property,
it don't matter, right?
It's assumed. Are you saying that it's assumed to be a 50-50 asset regardless of who paid for it?
Yeah.
Okay.
If you're both on there,
right?
Because I mean, as you can imagine, let's say me and you have a house,
right?
First 25 years, you're the one paying everything.
Right.
And those last 5, I get a big lump settlement and I pay it all off.
Mm-hmm.
So it's like those first 25 years, you get 90% of it and I keep 10, and then now I paid more, so now I get it. They just treat it 50-50, right?
Okay.
Now you can maybe have a claim, and that gets a little bit messier. But with regard to, so in Texas, there's technically no thing called common law marriage. It's informal marriage.
Wait a minute, bro. Okay, you got to break that down.
Hey, that's been the biggest.
You speaking to the spirit of thing that got some people bound in the mind. You breaking some generational curses and spiritual curses right now. Yeah. Say that one more again, lawyer.
So Texas law it's called an informal marriage, not common law marriage.
Okay, and what does that mean exactly?
Yeah, so informal marriage is something that, first off, is not assumed. It is something that has to be proven. So the instance where the person's saying, like, we're informally married or common law married, that doesn't really make sense. There's different jurisdictions, I think, that have like 10 years and they've been doing this, that, and third, living together. That doesn't apply in Texas. Texas, there's actually four criteria. Yeah.
Do you hear how he cut the people up right now?
It's like 4 criteria. So break them down.
Okay, break them down.
They kind of roll into each other. But the main thing is you have to intend to be married.
Intent.
So
Okay.
obviously you need both people have to have that intent, right? So it can't be one person who's like, look, I always thought we were kind of married.
Right,
The
yeah.
other person's like, absolutely not. So you,
Both people have to intend.
Intent, yeah.
That's
intent.
it.
That's juicy.
And the intention has to be proven.
yep.
And how do you prove that? Go ahead on.
And interestingly enough, and I think this might help a lot of folks, that intent is pretty easily disproven if you're engaged. And
Okay.
so the idea is, if we're engaged, that means I hate to use the word intend again, but in the future want to get married. That does not mean that we intended to be married right now.
Yeah.
That's a good one.
Yeah.
So it's always interesting when people are like, yeah, we're common law, we were engaged. And I'm like, no, that means that
We was
that
gonna
kinda-
get married later on. We
Right.
ain't married today. So putting a ring on it can buy you some time.
Yeah, right. It kind of works against people, which is actually, I mean, you can imagine that kind of reverse. You have to hold yourself out as married. And so the idea is, in the community,
You saying you married.
right, we're married. Everybody knows we're married. We act like we Mr. and Mrs., whatever it is, we act married.
Everybody need to hear that now. All you actors out there.
Yeah.
Yeah, the acting get you common law. They get you informally.
Actors.
Yeah. But you have to prove, I mean, as you can imagine, this is all, I mean, this has to come before
So
the court.
somebody introduced that, man, this is my wife. We ain't married yet, but this is my wife.
Yeah, don't
though.
use the word
That's
wife.
acting.
Man, I got some different cases I could talk to you. Actually, remind me to tell you, there's two different cases that are pretty wild. But yeah, because you got some people, in this case, it was like, look, oh, here's a picture of my engagement ring. So it was like, so wait, were y'all married? Now, Texas will acknowledge a marriage outside of the state or outside of the country, but this was like a community marriage, like a traditional marriage in Nigeria. And so we were trying to figure out whether or not that's a valid marriage or if that was just an intent. So they're not doing engagement rings in the same way. So it was this whole huge back and forth that could take a lot. But back to being informally married. So you have to intend. Both people have to have the intent. You have to hold yourself out as married. And so a lot of times that can be you're on. I mean, a good example, I guess. Let's say y'all have like an anniversary party or something like that, where it's like.
Yeah.
Clearly, y'all are saying that y'all are married.
Yeah.
You have to reside, and this is real squishy. You have to reside in the state of Texas together. Now,
Okay.
For how long?
well, that's the thing. So there isn't a time set on there, and there's a case where an individual, I think he was like a trucker or something,
Yeah.
and so they were living in her house when he was in town, but he wasn't here frequently enough.
Yeah.
But they considered that substantial enough to meet that element.
Wow.
That factor. And so,
Because he traveled for work.
yeah, I mean, and the cases behind there are very interesting because some of it is, you're sending out invitations together, or again, you guys have a party together. How does that work? Wow, man, one of the things that this case, and if I got time, I'm gonna tell
Yeah, you
you.
do.
Go ahead, you got it, bro.
So there's a couple, is the same sex couple.
Okay.
So obviously, 2015, Obergefell. Prior to that, Texas didn't acknowledge same sex marriages. So this couple had been together prior to 2015, and they broke up in like 2020. And they had a agreement, and it was like printed out because they had been living together, they've been paying the mortgage together, et cetera, et cetera. Like, hey, you keep the house, you give me $30,000, et cetera, whatever. So when one of them passes, now they had a will, and each of their wills left everything to each other. When one passes after they've broken up, the friends, because obviously they're like, man, you abandoned our friend, et cetera, et cetera. She's the executor on there. It's like, she should be cut out. Because if you get divorced, a will, it's almost as if you don't exist. It kind of gets taken out. But the problem is they were never married. And so you have a claim that, well, maybe they were informally married to be able to cut the ex-lover out of the will. Otherwise, you're just friends under the eyes of Texas, right? That's why I say when you're divorced, you're divorced. When you're married,
Wow.
you're married. And so what?
So how did that end?
Well, the court said. So the person that's still living is like, I didn't intend to be married. And so now you have, a deceased person that can't prove the intent element.
Wow.
And at the end of the day, although they have been broken up, and the siblings for the decedent who would have gotten everything else, but for that will was still deemed to be valid. And again, some
So
people
they get
like,
nothing. Get in.
not the siblings of the person that passed.
So
because that will still control.
and the ex mate got everything.
Yeah,
I need y'all to listen. I need y'all to listen out there.
Nothing like that.
Not y'all. They was no longer together, but she reaped everything that the person left behind
Didn't
because the
update that
trust
will.
and will was not taken care of properly.
Didn't update it.
Yeah, updating your will is important, you guys, and
It
that's
is.
why we do unlimited updates.
It's a sizable estate too. I
Yeah.
was like,
and the siblings just have to stand by and watch.
there was a
Yeah,
lot.
they just got to stand by and watch.
Yeah, and so it's the beauty of a
I
will.
pray for everybody's peace of mind.
Yeah, man,
Yeah.
put it down. You can holographic wills. Texas is one of the few that can do that.
That's Brandon. That's tough.
Write down on a napkin, wherever you're at. If you got a paper towel, you can write that down. I can write it here on this table in front of me. This is date, my name. I leave everything to my wife and sign it. This is a valid will.
Yeah.
Do something instead of doing nothing, because you find yourself in some
Y'all
crazy
hear him, don't you?
situation.
We brought the lawyer to y'all. This is Harris County's probate lawyer. Now, I want to ask you some real probate questions, right? Because we're going on a tour, you guys. I'm going to just go and say it and play it. We're going on a 12-month tour together. Let them know. We're kicking it off on October the 11th, right?
Yeah, October 11th.
And that's going to be a Good Hope, right?
That's it. We're gonna start off in Third Ward, kind of get it going. Yep. And then so October 11th. So we're keeping it the second Saturday. We're gonna try to keep it easy for people.
Yeah.
So it didn't bump into any holidays. So
Beautiful.
Then November 12th, we're gonna be up in Fifth Ward.
Yeah.
December 13th, we're gonna go out to Baytown, go check out our
That's
brothers
love.
down by the bay.
Yeah, beautiful thing.
Yep. And then I can keep going, or you wanna?
Yeah, give me 2 more.
Okay. And then January 10th, after the holidays, we're gonna be in A-Leaf.
Yeah. Don't play with the leaf, baby. Y'all know
man.
Mighty Ram over here.
And usually that's what people, that holiday season is like always when I was in private practice, the biggest uptick. Because people are sitting at the table like, wait a minute, what happened to
Yes.
Uncle Ricky's
That's when that
land?
conversation really
when
needs
was the
to
last
happen.
time? Did y'all get paid anything this year? We were supposed to get royalty.
Yeah.
And that's when people start looking at that dinner table and be like, weren't you supposed to?
Yeah.
So coming out of that, I expect that A-Leaf one to really be a big
massive.
one.
And what we want to talk about, the way that probate works, he's representing someone has already passed, the land has been left, and man, you know what, I'm gonna let him, he can talk about him better than I can.
Yeah, so the way that I describe, so the biggest thing with probate is who has standing, right, to do something. And obviously sometimes when you got that informal spouse claim, technically you don't have standing until you prove it, but that's another issue. So this office has standing under Texas Estates Code 455 to step in when you have an estate with no known heirs or no suitable heir. So a good example is a property that trying to think of one that we have currently. I'm gonna say over in the kind of East Houston area, and the individual passed. She has property there. She actually has some property up in Hempstead and somewhere else.
Yeah.
And an older lady. I'm not sure where her kids are. I think one might be incarcerated. And right now, she's still getting deliveries because she had auto pay on Amazon, and so the tax foreclosure hasn't happened because she had the auto payments, but no one's there, and the assets just wasting. Right, they're getting hit with fines and liens and whatnot. And so, in that instance, this office can step in as a universal heir or like an administrator of last resort to be able to kind of bypass all the headache of notice, and allows me to, this office, to serve as the administrator of the estate. So we kind of wind things down and find the heirs and make sure they get the assets. Because typically what happens is if there's a foreclosure, I don't know if you all do this, but probably if you don't, I bet you already started. Right.
That's
right.
So whenever there's a foreclosure, you can get the process. You can either do something called redemption to either get your property back within a certain period of time. You usually pay 25% on top of what was paid at the auction, or I mean, obviously you lose that property, but you get whatever those proceeds you have to pay to get your proceeds out.
I know all my assistants listening to this is writing this stuff down.
Yeah, absolutely. So whenever there's a foreclosure and there's a foreclosure sale, let's say whatever amount is above and on top of the back outstanding debt, you can get that amount of money, and you can get that amount of money, or you can try to get your property back.
Yeah.
The problem is, one, who has standing to get that property back? Because if you still haven't probated, then you don't have authority to get your property back. The property's not in your name. So as you can imagine, it happens a lot, especially like around communities.
You spend money both ways.
Going in and out just to get your own stuff back, but you haven't probated that. So that's one of the issues. And then the other issue, like I say, if you're trying to do the redemption process, it's not hard. Sometimes these are developer or investors, like they'll just buy something and they'll try to duck and dodge you. They changed the law, so now you can just put that 25% on top of the value or that what they pay for it, and just put it in the registry of the court and then get that title cleared up. But otherwise, people just try to duck and dodge, and then if you don't do it within, I think it's basically like the first 120 days, they try to keep it.
Yeah, we got a couple of minutes left on the show. Of course, he is from the Harris County Public Probate. The administrator, Brandon Cofield's been hanging out with us, sharing valuable information for us today. Getting ready for the big tour, which is going to kick off on October the 11th at the Good Hope Church with Pastor Cofield. Cofield's going to be a great time of information for you to come out with the family. How can everybody keep up with you as well? Because I know in this short period of time, we have a million questions that we'll never be able to get to. Yeah. But for more information, how can they follow you as well, Brandon?
Yeah, so the best way, we have our brand new website. It's ppa.harriscountytx.gov. Hopefully what we're trying to do, because right now there's just a lot of not only misinformation, there's information in a lot of different places related to probate. So we're trying to consolidate that to help people out. And that's part of the reason why we're doing this tour, is trying to make sure people know how to, one, get the property correctly titled, and two, know how to distribute it correctly later on down the road. And so the idea of calling it the Family Home Workshop is like, all right, you got a family home. Yeah. So that hopefully that'll trigger, for people that are thinking like, all right, yeah, I got one of those. We got Harris property somewhere. Now, how do we clean this thing up so we can move forward? But the best way is via checking out the website. If not, I can always email. I respond as quickly as I can, but it's just brandon.cofield@harriscountytx.gov, and that's the best way.
For sure.
And the beautiful thing is what he does with Harris County Probate and what we do with Trust and Wills marries well together.
Yeah.
So we go out into the community. We're going out into the community together. We're doing 12 months. It's a year of us going out in the community, going throughout the entire Harris County, making sure that everybody in Harris County protects their family, home, and legacy.
You can do it right now. 281-576-9119. 281-576-9119. 281-576-9119. Brandon, thank you again for coming on. Let's Talk Business with Crockett and AV. When you see the C,
you know it's me, and when you hear the C, it's Dr. Crockett and
AV. 281-576-9119. 281-576-9119. Get on the phone right now.
Beautiful thing.